Hi, everyone. We'll get started in just a few minutes. I see people are still joining, so thank you, Stephanie.
Yeah, thank you, Stephanie. You're a wonderful cheerleader. We need it. We may have so much to cover that we want to go ahead and jump in, and people can just hop on in as we're going.
Yeah. Well, and we are going to record this, everybody, but welcome to the Dallas Women Lawyers Association's June virtual CLE. My name is Melissa Gray. I am the VP of Programming this year. Thank you, everybody, for giving us your time and attending. We have a really exciting and relevant and timely presentation for you today entitled Eyes on the Future, Privacy and Technology in 2023. The virtual stage is going to be shared by three presenters that are experts in their field, and I am going to allow Kate to kick it off. But before I do, housekeeping, the CLE link to receive your credit will be in the chat at the end of the presentation. And if there is time for Q&A, if you have questions, go ahead and put them in the chat and the ladies will try to address them at the end. But without further ado, take it away, Kate.
Hi, everyone. Welcome to Eyes on the Future, Privacy and Technology in 2023. We are going to cover so much today, starting with legal ethics, and we're going to explore a hypothetical, do a lot of issue spotting, and reach a conclusion. But first, we're going to meet our speakers and presenters, our futurists here. I'm Kate Morris. I'm a co-founding member of Hosch & Morris. We're a boutique law firm in Dallas that's dedicated to data privacy, information security, the internet, and technology. For most of my career, I have been in private practice, so I am thrilled to have the varied perspective that my two co-presenters bring, and they are incomparable women. We're going to learn a lot from them. Diane, why don't you introduce yourself?
Good afternoon, and thank you for having us. My name is Diane Reynolds, and I'm a shareholder at Greenberg, Traurig. I have been in the cybersecurity field since I was in-house counsel for the largest privately held hosting company in the United States, headquartered in Columbus, Ohio, of all places. And Kate and I have a long and varied history of collaborating.
Sandy?
Yeah, hello, everybody. And I am Sandy Kirsch. I'm a global privacy counsel and consultant. I was formerly the chief privacy officer at KPMG International and led the privacy practice at IBM Global Services, formerly to in-house counsel at American Express for privacy. And Kate, just delighted to be invited and excited to be here with you all today.
Thank you guys both for being here. Before we get to our hypothetical, let's explore some ethics, because this topic kind of complements everything that we're talking about. You all may have heard the recent news about the lawyer who used AI to write a brief, failing to understand that he couldn't rely on its accuracy. He turned in the brief. It was full of inaccurate citations, and he expressed his shock and horror that he couldn't trust the AI output. Well, you know, he wasn't aware that the AI could hallucinate, but that is a very basic risk of AI. And as lawyers, we have a core ethical duty of competence under Rule 101 of our Texas disciplinary rules, under ABA Rule 1.1. And this duty of competence includes the requirement that we keep abreast of changes in the law and its practice, including appreciating the benefits and risk of the relevant technology. And that's something that we hope this presentation will help all of you enhance your competence in that regard. Second, lawyers really have a duty to communicate with their clients, and they have to provide sufficient information to allow their clients to make informed decisions, including decisions that relate to technology. And today we'll be counseling a hypothetical client and attempting to show how this communication might work in this context. Third, we have a duty of confidentiality to our clients, and we shall not reveal information relating to the representation of a client. Of course, that's absent specific informed consent or some sort of implied authorization. But a necessary corollary to this duty of confidentiality is that lawyers must at least make reasonable efforts to prevent the inadvertent disclosure of or unauthorized access to information related to the representation of client. And related to that is the safekeeping duty that we have. We have ethical obligations to safeguard client property, which includes data. And that means that lawyers need to understand what data they're collecting, where it's being stored, and how it's being secured. And we're going to talk about that a lot today. Finally, we have a duty to supervise subordinate lawyers and non-lawyer assistants. They have to comply with the same rules we do, and that means we must establish policies and procedures to ensure their compliance with our rules, and that includes entering into contracts with vendors. Before moving on, we want to commend ABA Formal Opinions 498 and 483 to you all. If you haven't read them, they have some prescriptive suggestions about cybersecurity in particular that you want to be aware of, and they'll be helpful, we think. Let's turn to our hypothetical. Meet Alton Samuelson. He is the founder and CEO of Black Globe Equity. Some people think he's a visionary. Others think he's a madman. But one thing is certain, Alton has his eyes on the future. Black Globe Equity has 3 portfolio companies: Everywhere AI, Prometheus Energy, and GlobeCoin. Everywhere AI is an artificial intelligence research and development company with a mission to ensure that artificial general intelligence benefits everyone, everywhere. Prometheus Energy is a future-forward energy company with a mission to deliver unlimited clean electricity by commercializing fusion energy. And GlobeCoin is a blockchain-based company whose mission is to build the globe's largest identity and financial network on the blockchain by issuing Globe coins to everyone who offers their retinal scans. So how this works is that Alton sees the promise of Prometheus's fusion energy to be able to power the great energy demands that AI takes. So not only power Everywhere AI, but power all AI companies. Further, he intends GlobeCoin is going to solve for 2 problems. 1, AI taking people's jobs, and 2, proving you're a person in the age of bots. He envisions that Globe coins will be used as a currency to provide a universal basic income, and retinal scans in combination with verified digital wallets will allow our world's digital systems to decipher humans from bots, thereby providing proof of personhood. Here is Alton's vision, and let's just say this out front. This is a flawed vision. So here's what he thinks. Alton likes control. The boards of his portfolio companies bow to Alton and do not have clear oversight over privacy and security issues. Alton is thinking of taking 1 or more of the portfolio companies public. This includes Prometheus Energy, which operates as critical infrastructure. He wants to build a privacy program, but only because he thinks privacy is good for PR. And Black Globe is facing significant issues associated with the scraping of data through Everywhere AI, an acquisition involving EU data, personal data, Prometheus Energy, and the collection of retinal scans associated with GlobeCoin. Alton hopes to mitigate risk by outsourcing a lot of the critical technologies and business functions that he is using for his businesses. As far as AI, Alton wants all Black Globe companies to share data so that he can further power Everywhere AI's models. And in addition, for mergers and acquisitions, he's considering acquisitions because his goal is to get more data and proprietary technology in order to grow faster. So let's start. We've said that Alton clearly has a flawed vision. Diane, would you please talk about why it's important to define the bounds of representation by asking, who is our client? What are the potential conflicts? And what exactly are we doing and not doing?
Thanks, Kate. Yeah, I mean, it's important here because we have an individual who purports to want to control. I mean, it's a sort of a global empire. So the first question from a conflicts standpoint is, who is the actual client, as you point out? obviously it's not the individual, it's going to be the company, but which one do you pick? Is it going to be, the parent company, Black Globe Equity? Is it going to be the each one of the different subsidiaries at this point in time, 100% wholly owned subsidiaries by Black Globe? I think it's probably, you're probably looking at just Black Globe, the parent company now, and you hold off and refrain from, representing the portfolio companies, because there may be a conflict later on. In terms of, what have you agreed to do to act as counsel for Black Globe? I mean, you're going to try to do a corporate governance policy. If all the companies are bowing to him, as Kate pointed out earlier, there's going to be a political push there to try and separate the companies. You're going to need to build a privacy program, but is that going to be for Black Globe, which is a holding company and not really an operational company? You're still going to need to drill down to the portfolio companies to find out what they're doing, in which case maybe at that point you extend the engagement. But once you've done, I think, probably a lot more fact finding and due diligence review from the law firm's end. I think those are my overall views.
Yeah, and then, we're going to deal with AI. We're going to want to limit how we're dealing with it. We've suggested on this slide that we're counseling on frameworks to address the risk presented by AI, but we've had a lot of internal conversations about needing to define that more particularly. And then with respect to the acquisition, saying exactly what we're doing, which is counseling on setting up a data room, addressing privilege issues, conducting privacy and cyber diligence, and negotiating favorable deal terms related exclusively to privacy and cybersecurity. I'll just say one other thing. If you're at a big firm, you're going to have to also watch out for issue conflicts. We are not going to provide advice related to securities, which is a very hot issue. And anytime you hear blockchain or get pulled into working on any company in the crypto space, you need to be worried about securities laws, and you need to make sure that is carved out of your representation if you are not offering securities advice. There may be other lawyers at your firm that are offering securities advice to companies that are wanting to do crypto offerings, and they're going to be taking a position that what the client wants to do is a security. Alton would be taking the position that what he is doing with GlobeCoin is not issuing a security. So being sure that you don't run into issue conflicts is another thing that you need to be thinking about when defining your scope of representation. Let's get to the next slide, which really has to do with, he's contacted us because, we're privacy people, but there are other data considerations and system considerations right here that we think have higher risk. And let's kind of begin by prioritizing cybersecurity and board oversight. So we know that Prometheus functions in the critical infrastructure sector. And so the cybersecurity part of that, because of the Biden administration's focus on critical infrastructure, is going to be key. That critical infrastructure cybersecurity is not just going to cover the personal data that Prometheus is dealing with. It's going to cover all of its data and systems, both information technology and operational technology. And so, Diane, I understand. He's told me, we just got off the phone, and Alton has told me that GlobeCoin is actually, it has a product. It's called the Orbital, and it's this little handheld device which is actually doing the retinal scans. So not only are we dealing with this fusion energy issue, we're dealing with this product, and there's security considerations there too, correct?
Oh yeah, definitely. I mean, BIPA, Illinois is going to be a major issue, as are, privacy laws in other countries too. I mean, that's going to be sensitive data. It's going to be healthcare data, and it's going to need to be handled much differently than some of the other, just personally identifiable information.
Yeah, and so we would need a lot more information from him if he has outsourced this, or where these product components have come from. Because let's say they're from China. The Chinese cybersecurity law requires companies to put backdoors into products. And that means that the Chinese government could have access to information. We need to know if that's a risk. It may not be, but we need to drill down into that product and advise him, listen, it's not just about the information, it's about the operational technology. You do not want your fusion power plant to blow up. And you'll all remember, or maybe not, because it hasn't really been that well reported, but the US and Israel years ago teamed up in an effort using this malware called Stuxnet to melt down Iran's nuclear reactors. And that is the kind of vulnerability we're thinking about here when we're saying prioritize the cybersecurity of critical infrastructure. But Diane, there's other things too. He's wanting to take these companies public. And so what does he need to be thinking about insofar as board oversight, going public, and what the SEC and NYDFS are looking at?
Well, from the SEC standpoint, I mean, you're going to have to disclose, cybersecurity risk. I mean, they have a proposal now that you must have at least one board member who is actually knowledgeable about cybersecurity sitting on the board. It's not just enough to, trot somebody in and they give a 15-minute, presentation and then they leave. It's got to be an actual person who's actually knowledgeable about the field that sits on the board and is responsible for reporting. And actually, we're talking about perhaps creating, like you have an audit committee, a governance committee, that you'd also have a cyber committee as well, because they're really elevating it. And DFS is leading the nation. The New York Department of Financial Services is leading the nation in requiring proactive requirements for its regulated companies to, basically put into place technical, operational, administrative measures to protect the integrity of the data. And that encompasses all regulated companies in New York or that do business in New York, and that will spread as well.
Yeah, and the reason everyone always is saying, why do we have to worry about NYDFS? And I just want to really put a point on it. It's because the standard for all of this is what is reasonable, and courts don't know what that standard is. And so they've looked to NYDFS and the regulation before to define what the standard is, because NYDFS is more prescriptive than other laws, saying you've got to have multi-factor authentication, you have to have business continuity plans, test, audits, patching, all of it. And so that's why it's important to keep your eye on that regulation. And also important to recognize that the SEC in its examination priorities this year has put information security on a top 5 list. And so they are looking at this. Now, Sandy, we're going to turn to you in just a minute, but let's just tell Alton this. This idea that he wants to keep control, let's counsel him off of it. And, there are real issues of executive liability. Right, Diane?
Oh, yeah, absolutely. I mean, as the slide is showing, I mean, you have personal, you can have personal liability. He says he wants to control everything, yet he wants to mitigate the risk by outsourcing major mission critical functions to third parties. They are not compatible. It's not a sustainable model.
And so can you talk a little bit about Uber?
Yeah, I mean, the chief security officer there was also a lawyer, and he was convicted of multiple felonies because he concealed a data breach during an FTC investigation. I mean, Uber is not, regulated like healthcare or financial services, so it fell under the FTC. And when they came in to look, he completely misled, misrepresented, and lied. And so now he is suffering the consequences of that action.
And that's the chief security officer, but we can even draw the parallel with Drizzly closer to what a CEO like Alton is. Would you like to talk about that?
Yeah, exactly. I mean, in that case, the CEO was just completely negligent. I mean, he did not have a senior executive on the board who was knowledgeable about cybersecurity or could inform them about the risks.
He didn't even have a security officer.
No, he had
And this
not.
was a consumer-facing company without a security officer. And so what the FTC decided to do is really make an example. And rather than just penalizing the company, it put the CEO under the consent decree. And so wherever the CEO goes, he's going to have the same data security and privacy obligations. And I would imagine that's going to, no one's going to want to hire him when he's
No,
coming
that
with
will have a chilling impact on his future employment plans, I'm sure, yes.
Right. And so then let me just highlight the SolarWinds. So you all remember the big SolarWinds hack. They were a provider to the Pentagon and a lot of other big companies of managed security services. They were hacked, and there have been derivative actions that have been filed. Recall that under Delaware's Caremark doctrine, directors on boards of directors have a duty to exercise oversight and monitor a corporation's operational viability, legal compliance, and financial performance. And under Caremark, directors may be held personally liable for failing to implement reporting or information controls, and then having implemented such controls, failing to monitor them appropriately. And so these cases are getting filed. There's a judge recently wrote an opinion, said they're popping up like flowers in spring or something to that effect, but they are coming after boards of directors. And here their 8K showed that they paid $26 million to settle claims made personally against the board, and they paid it out of a D&O insurance. So if you're counseling companies in this area, I would suggest that everyone wants to really look at the D&O insurance and make sure there's sufficient coverage for these kinds of claims. Now, Sandy, we have got to talk Alton off this idea that privacy programs are only for PR. So can you talk to that and talk about exactly how he should be thinking about building a privacy program?
Of course, and thank you, Kate. And as far as it being only a PR effort, I mean, really what a company wants to do is to build brand and build trust. And that's one of the great benefits of a privacy program and being in a compliant posture. So that's what he should be thinking towards, that he was going to be increasing his business by determining the level of risk he wants to take previously in a strategy, and then mitigate around the other risks. And the way typically this is done in a company is to establish a privacy program. It can be done in accord with a number of frameworks. You've got the NIST privacy framework. ISO has a privacy framework that also has security controls. And this provides you an overarching mechanism across an entire enterprise to establish what can be thought of as controls. But really, beyond that, and then those programs can be used to loop into something like in the EU for binding corporate rules. It's allowed if you have a certification. If you did an ISO certification, that would be a mechanism that would allow you to transfer cross-border data.
Let's talk about this. Let's talk about kind of the jurisdictional issues involved in all of this.
Sure. And what I wanted to say too was that really what he's going to be doing is sort of assess, plan, design, implement, run, monitor across that program. And he's going to be having to look at his geographic spread, that, where are his businesses, and then what are the laws and regulations that apply in every area. So he's global, and the big ones will be for him, US and EU. And then he's going to have to comply with those, and those will impact every country. You'll have to do sort of, well, the best thing probably would be to get a top-down framework if he's got a single entity, and then fan out and customize by laws in countries.
And he can't do that alone, can he?
No, but what part of that program for him should be, he's got to have the coordination with the board. He wants to, first of all, be communicating with the board and have board representation, having the privacy officer communicate with them. Then they need, a budget to ensure that there's funding for the program. And what would happen is, we, advise him to look at all the laws and regulations that are appropriate. And then the requirements would flow out of that. And those requirements would then map back to the frameworks and the local laws of the countries.
Yeah, and so a lot of executives seem not to understand kind of jurisdictional issues, and they think, oh, we're based in the US. And just so you know, like the US is the last and the only developed country not to have a comprehensive privacy law. we are seeing an upsurge in what's called state comprehensive privacy laws that are more consumer focused. Diane, would you talk a little about that?
Yes, I mean, as the slide points out, I mean, California usually leads the way, and their legislation has been now duplicated. There's probably, that I know of, 5 more that our bills are pending and waiting for signatures at the governor's office, that other states will come on board. Kate, I don't know exactly where this is going to go, but we're not going to be able to have 50 different, state prescriptive requirements for how to do business in that state with respect to cyber.
It really gets difficult. Yeah.
Yeah.
No, I agree. And just to
Yeah.
mention this, Governor Abbott signed the new Texas law into effect just this week. And so, where we can't really deal with all of these different laws, we have to think about basic and similar privacy principles. And Sandy, would you talk to this slide? I know in our preparation, you said this could be the most important slide of the presentation, and I'd like you to expound on that.
Sure. And if you take, there's so many laws coming down right now, and there's so many different requirements. And a really good way to kind of keep a focus on this and establishing your program and providing legal counsel is to map back to the principles. And originally there was the FTC's Fair Information Practice Principles. And those were elaborated by the EU General Data Protection Regulation, and which took into account consent, legitimate basis for processing. And now China has a slight tweak on that. But these are really the framework things that every law is different. I mean, you'll see in the US, we've added a layer to GDPR by bringing in marketing and a sale and opt-out requirements. But if you can focus on the fair information principles, that'll allow an internal structure that can be tweaked then to incorporate the different laws and regulations globally.
Sandy, would you talk about kind of the difference in what privacy means in these jurisdictions that we've highlighted?
Sure. And a lot of the tension that goes on in privacy is because the EU has really, since the outset, been the driver in this. And in Europe, privacy is considered a fundamental right. Here, we have privacy, but it's not in that fundamental human rights sense, and it's being chipped away by Dobbs. So what's happened is, especially with the large tech companies here, there's a tremendous tension between the United States and Europe, in terms of the protection that data receives when it comes here. And that's led to a lot of the establishment of provisions around cross-border transfers. And then now what's happening is with China, since it's not a democratized society, they're seeking to keep the data localized, and all their laws focus towards that end. So you have a global tension in different data protection regulations and requirements.
And let's talk more about that, Sandy. So, one of the things, our data transfer is a hot issue out of the EU and now out of China. But can you talk about kind of what adequate give us the background of EU data transfers, adequacy, not adequate, all of the drama, fill us in.
Okay. Well, there's been a lot of drama around this, and we'll also see that Alton would like to, transfer data. So he's going to need to think about this and how he's going to structure it. And primarily because of the difference in relevant weight given to privacy between the EU and the US, there's been provisions around cross-border data transfers. And what that means is when data is transferred from a European citizen to the United States, Europe feels that it needs to be protected. And the standard ways in which it was protected, and it's being protected against government surveillance, essentially. And it was protected by the safe harbor and the privacy shield. And what happened is there were 2 cases, Schrems 1 and Schrems 2, that knocked down those mechanisms. And those were global mechanisms that companies could use, sort of a privacy compliance program, as it were. And there was a third mechanism called standard contractual clauses. And those were established by the European Union, and it allowed data to come over with certain protections. And there have been multiple versions, but in the latest ones, because of Schrems 1 and Schrems 2, those requirements have been boosted, and you have to do a transfer impact assessment, and you have to have supplemental measures in order to transfer data from the EU to the US. And the latest drama has been Facebook, or Meta now, the decision that came down just, a month or so ago, saying that the Meta was using those new contracts, and they had done the transfer impact assessment, and they had put in place supplemental measures. And the Irish court and the European Data Protection Board, working in tandem, have found that not to provide an adequate level of compliance. So what does that mean? I mean, that's an issue for Meta, but it potentially could be an issue for every company that's transferring data out of the EU. And one of the developments that's may negate this, but it's a timing issue, is that the US now has a data privacy framework that the Biden administration has put forward that might allow for the United States to become what is called an adequate jurisdiction, that would allow the transfer of the data here and boost the situation with the standard contractual clauses. It might not remediate it entirely, but that has not been determined yet.
Yeah, so let me just break it down like in the sixth grade explanation.
Okay.
The EU is like the parent who will not let their kid go to people's houses unless they know that the liquor cabinets are locked. And any jurisdiction where the liquor cabinets are locked, data protection laws are the same as how the EU expects it. They'll let the data go there. In the US, they don't think the cabinets are locked. And so to get their kid over, to get the data of EU citizens over here, something else has to happen. And that something else is either putting in a contract or ascribing to this framework that used to exist that does no longer. And so right now, everything is up in the air, and it's creating a ton of tension with technology companies that rely on moving data around the world freely to do that in a way where they're not getting hit with $1.3 billion fines, which seems to be the EU's kind of the way that they've chosen to deal with this. Now, China has also put in some new cross-border transfer mechanisms, and we all agree, if you're dealing with China, you need a Chinese lawyer to help you. But Sandy, is there anything else that you'd like to say about the China mechanism?
Yeah, just a little bit. I mean, this is another thing that Alton's going to need to think about, because in China, there are 3 right now essential mechanisms by which 2 of which are active, which you can transfer data. And there's a security assessment that's mandatory, and that would be for companies that have critical infrastructure. And since Alton, is going to have critical infrastructure, he'll probably be subject to that. Then there's standard contractual clauses that are available, but again, it's a criteria issue. But both of these involve doing an assessment of what you're doing, you're transferring, and how it's protected. And then there's finally a certification mechanism. But yeah, I can't stress enough that I think with China, there's translation requirements, there's Chinese law requirements, there's deadlines, there's a lot of fine points. And it's really good to have local counsel there that can be representing you. I mean, that's good in every case. To have a local lawyer, but really in China, it's almost mandatory.
There are some really unique issues over there, and it's just something to be aware. Chinese judges can be disciplined if they rule in a way that is adverse to the government. So when you are relying on local counsel, just keep that in mind. And when you are thinking about Chinese law, recognize that the way the laws are written give the governments all kinds of rights to access what they deem as important information. In fact, there was just a revision to the espionage law, which not only now allows the government to access whatever information it wants for national security purposes, it can do it for, I forget the exact phrase, but it isn't defined. And it basically just means they can do it whenever they want to do it. And that's going to be an issue and something that needs to be thought through when you have data coming out of China or are doing any kind of contracting for the development of products there. Let's kind of move on, and we need to talk to Black Globe Equity and disabuse its CEO of his notion that he can outsource his risk. Sandy, do you have something to say about this?
No, go ahead, Kate, on this one.
Sure. So, I think the 2 big examples that I would say to him is, Amazon Web Services is the biggest of the big that people can go store their data with Amazon Web Services. And you'd think, Amazon would provide sufficient security and privacy by default. But the FTC does not think that, and has made examples of Chegg, and this week, or I guess it was last week now, One Health, that was this week, One Health IO, and in part faulting them because they relied on AWS but failed to properly configure their environments. So with Chegg, the insufficient security was a failure to implement access controls and utilize multi-factor authentication. With One Health, there were a lot of other problems, but the problem related to AWS was that they were storing sensitive information in an unencrypted environment. And the FTC does not want that. If you have sensitive personal information, it absolutely must be encrypted at rest and in transit. So, I think for Alton, just recognizing that the FTC is not looking to AWS for this. It's looking to the companies that are relying on AWS. He's not going to wriggle out of anything by outsourcing. I think the other kind of areas, and I'll move through this quickly. GoodRx and BetterHelp are two other cases brought by the FTC. Both of these platforms had to do with health information, and both of these platforms were presumably relying on service providers to provide their platform, their online presence. A lot of times when that happens, service providers will integrate, perhaps advertently, but perhaps meaningfully and perhaps inadvertently integrate technologies which the platform owner does not expect. And in this case, they integrated Facebook Pixel to the effect of when people interacted with these platforms and put in their personal health data, Facebook was alerted. Facebook had visibility if they were logged into their Facebook, and then Facebook started feeding ads to the people that were related to whatever they were doing on the platform. So if someone was trying to find a deal on a drug, they'd start getting ads for the drug and for, other drugs that might complement their health condition. And people did not appreciate that. The FTC certainly didn't. So Pixel is a unique sensitivity. Also, on the right-hand side of the slide, the California session replay litigation. Session replay software is software that runs a lot of times in the background on websites that allows the website owner or their vendor to see how you are moving your mouse and otherwise interacting with the site. It's uniquely sensitive because California's Invasion of Privacy Act is a class action hotbed. We'll talk about this as a theme, but basically any kind of statute that has statutory damages and a privacy element tends to attract the class action lawyers. And here there have been so many class action filed against websites that are running session replay software. And so just to mention this case at the bottom, Javier versus Assurance, it's unpublished, but it just shows kind of where courts are. And that's a little bit behind. What the court said there is that in order to use session replay software, you need to obtain prior express consent from the website user. But what the problem is that if a person visits a website with session replay software, they just are there and the replay software is already running. There's no way to get prior consent unless you're using like two separate environments. Technically, it's pretty impossible. And so that's just, courts have not caught up to the issues, but we're just going to tell Alton, the law holds the company collecting the information responsible with regard to however it stores it, however it processes it. And it doesn't matter if it stores it itself or outsources that storage. You have to get your supply chain, your data supply chain in control with contracts and the appropriate security measures.
All right. And Kate, just before we go on from the slide, we're also seeing, to come back to the health piece, we're seeing a much more active FTC right now. And a lot of these cases, typically health privacy cases, were brought under HIPAA. But now the health breach notification rule has been used in a few of these. And what's also happening on the state front is we're seeing local state laws. Washington State, My Health, My Data Act, Nevada passed an act. And what it's doing is seeking to fill in this space, maybe where you're ordering things online, that because HIPAA's typically covering treatment, payment, and operations, but there's sort of a gray area that the FTC is trying to address where consumers are now maybe making purchases or doing other activities online that they're trying to get to in some of these enforcement actions. And you'll see when Kate talks a little bit about Dobbs, you know, the further expansion of this health concept.
And we're going to just like glide over this. I just want to highlight Dobbs and the kind of focus by the FTC on precise geolocation data. What happened in Dobbs is that it cast doubt, Clarence Thomas expressly in his concurrence cast doubt on whether the right to privacy as recognized by the Supreme Court indeed exists. And you'll see a link at the bottom about what the Supreme Court has said about privacy. I commend that to you. We also have some thoughts about what Justice Thomas said and his reliance on this Wayland case, which is controversial. Anyway, you know, it was, I think, Roberts who acknowledged that the Dobbs decision was just absolutely an earth-shattering decision to precedent. And it's cast a lot of doubt as far as privacy precedent. Well, the FTC has picked up on this and brought two cases, Kachava and this Easy Healthcare Corporation, which is new, really focusing geolocation data as it's sold to companies that could potentially track women who are seeking healthcare services. And so they do not want this information shared with Google. They really do not want data brokers selling this willy-nilly to whoever wants to buy it. And they're looking at that practice with scrutiny. So that's just something to be aware of. Not exactly directly relevant to anything that Alton is thinking about, at least that we know of, but I do want to highlight that. And also, you know, the risk associated with biometrics, and I'm going to take this slide and then let Diane and Sandy carry us into a broader discussion about this. Biometrics, fingerprints, retinal scans, things that are associated, indelibly associated with a human as an individual are uniquely sensitive. It's uniquely sensitive data. In the US, the sensitivity is quantified because of this class actions, again, the statutory damages law, the Illinois Biometric Privacy Act. It requires very prescriptive things to comply. And you have to obtain written consent. You have to notify individuals that their data is being collected, how long it's being retained. You've got to have retention plans in place. You've got to destroy this information. Diane, there are two new cases recently. Will you highlight them and talk about what you think their effect might be on this overall BIPA liability environment?
Yeah, well, on the first case there in point, Black Horse Carriers, you know, the 5-year statute of limitations is going to apply to all provisions of BIPA, not just the 1 year, you know, time limit, which is what the business community wanted. And then Cawthron is, you know, each time someone's biometric data is collected, you're going to have a separate violation. I mean, from a commercial corporate standpoint, I mean, those are just untenable. I mean, the risk there is almost, you know, unquantifiable. And
it is, and you know, the greater risk too is that all of the cyber insurance carriers are now excluding claims under BIPA. They're excluding Pixel, they're excluding session replay. And so it's time to get house in order and recognize the risk. And I'll say this, in practice, what happens is that companies will go contract for cameras or timekeeping software or other technologies like vending machines where they don't even realize that there is a biometric component that is built in because they aren't diligencing properly. Right. And then they get this technology and suddenly they're like, I didn't know we were taking biometric things. And it's like, well, you've got a problem. And so it's really important to diligence and know what you're getting, contract appropriately, and then take the steps to comply with the Biometric Information Privacy Act. Sandy, quickly, biometrics across the globe are getting a lot of scrutiny. Can you speak to that quickly?
Sure. And Alton has his little machine for scanning retinal scans. And in the EU, biometrics are considered special categories of data, which are expressly prohibited unless you have explicit consent for one or more purposes, or unless that data is manifestly made public by the data subject. So what's going to need to happen here for him is he's, you know, and it should be done just generically, is he's going to need to do a data privacy impact assessment, really analyze the way that this product is going to be used, and then vet it against global laws. And Europe, there's the GDPR, which I just described, but there's also the AI Act, which we're going to talk about in a minute, which has certain categories banned and certain biometric activities banned. But it is sensitive personal data. It's subject to more restrictions. And then that's going to mean that he's going to have to comply across the globe with many different regulations and be able to release it or operate it in, in accord with those.
Yes. And so let's quickly highlight the blockchain privacy issues. And I know blockchain is mysterious to a lot of people. And so I'm going to try to do this quickly. Just to tell Alton, here's the problem. We can help him if, let's just say that GlobeCoin is a centralized company and not a foundation, as a lot of blockchain players become foundations rather than corporate. But let's just assume that this is a company. If it's a company, it's got the same issues as every other company as far as kind of the centralized collection of data, how it's being processed, what the obligations are. The entire kind of data privacy landscape, all the laws are built on a paradigm that recognizes an entity, or maybe two, being responsible with what data they collect and process. That will flow down to who their sub-processors are and all of that. But the paradigm is that the data goes from an individual to an entity. On the blockchain, decentralization, as Vitalik Buterin, the founder of Ethereum and kind of a blockchain god, said, decentralization is often viewed as the blockchain's entire raison d'etre. And what that means is that you don't have a single entity collecting that information. It's distributed across the network. And so to the extent that we are talking about distributed data that's been distributed across a blockchain, a decentralized blockchain, we cannot help him there because the laws do not deal with that kind of environment. We can help him on the company side. And that's just the point that I want to make. When we talked earlier about how privacy means different things in different jurisdictions. In the blockchain world, when people speak about privacy, they aren't speaking about data privacy. They're speaking about pseudonymization, in that you don't have your name on a blockchain. You have your wallet ID, a pseudonym of numbers and letters that represents you. That's a different concept, and it comes to a bigger discussion about what privacy enhancing technologies you can employ on the blockchain, but it would have to be a very careful discussion with Black Globe and especially GlobeCoin as to what we can and cannot do for them and to where they need to be sensitive, which would be for the blockchain, thinking about the privacy enhancing technologies. Let's move to AI. And he's got some AI issues with everywhere AI, starting with scraping data, but beyond that, Sandy.
Yeah, Kate, do you want to go with the US and I'll pick on in the EU?
Sure. So I think really the problem right now is that it's been wheels off. We understand that he is moving fast and breaking things, and his developers have gone and scraped data off of websites. So taken automated tools and taken all kinds of data. That could be personal information, which implicates privacy issues. It could be IP. So in doing this, you potentially violate the Computer Fraud and Abuse Act. You potentially breach contracts by violating terms of use. You have IP infringement. There are all kinds of issues. And if you don't have a framework for addressing the issues that AI presents, which the scraping issues are just one of many, bias, how you're accountable, if you're secure, building things that aren't a black box that you have visibility into how they're actually working. If you all haven't seen The Class of '09 on Hulu, there's a whole series now on this, which is very illuminating. And I would say watch it if you want a dystopian nightmare to haunt you at night. Personally, I find it delightful. But anyway, this is kind of having a framework and telling Alton that we need to kind of have a systematized way of addressing these things. The laws are evolving. NIST is a recognized framework. The White House has put out a framework, but there are others. Sandy, why don't you talk about what's happened in the EU?
Sure, and the importance of the framework is critical because it'll at least give parameters around what is done. And NIST is just excellent for the United States. And what is, you all probably know, I mean, in the last week, there's been so much about what's going on in Europe in terms of artificial intelligence. And they were the first out of the box, or one of the first early in 2019 to come out with ethical guidelines for trustworthy AI. They were thinking very critically about this, not just in the data privacy space, but privacy as a piece of the entire deployment of AI. And you see the principles here. And these would be two really good documents to read if you have time, because it'll give you a framework for the rest of the world. So those ethics guidelines are there. And then what happened last week was that in Europe, the parliament passed the version of this AI Act. And now it goes into something called the trialogue, where the parliament and the council and the commission will come up with a final version that is due to come online hopefully 2 years from now. And this will govern artificial intelligence, within the EU bloc. And it's a principles, but it's also really a risk-based framework where certain applications are banned, certain are considered high risk, and then it flows through from there. And Parliament actually put in prescriptions for foundation models on AI, and even further transparency requirements for generative AI in their version. And we'll see where that comes out. But the real problem is it's sort of like the horse is out of the barn. And you'll see this AI code of conduct here and the AI Pact that have now been put forward by the European Union to get a code of conduct out that can provide some guardrails, as it were. That's what it's being called, guardrails in the interim while the AI Act comes online. And also an AI Pact has been proposed that companies would sign on to. So it's really a situation, I mean, in every country, there is a map that shows every country is coming up with some kind of guidelines or regulations. And, I get emails daily about enterprise privacy policies around AI, or company code of conduct, or data privacy impact or AI assessment. So what it's really just critical to keep in mind, in the ICO, which is the English Data Protection Authority, UK now left the EU, has just said that they're going to be checking, and they just want to make sure that it's not really with AI. It's it's not to be just to prevent it. It's just to ensure that the risks are mitigated and consumers are protected. And these frameworks are designed to do that. But
and I just want to highlight this, and I know this sounds doomsday, but we're not just talking about inaccurate citations submitted to court. We're talking about the potential for an artificial general intelligence to recode itself, to reprogram itself, and to do things that we have no idea why or how it's doing it. We're talking about the ability of AI potentially in the future to build, use CRISPR technology to genetically engineer some creature, build beings that we have no concept of. We've got to find ways to have human oversight of this technology, and it isn't just a privacy issue. Privacy is a tiny piece of it. It's far, far bigger. And so that's the kind of what we would like to highlight to Alton. Let's pick a framework and let's start trying to think about doing this more responsibly. Let's go to mergers and acquisitions in the time we have left. Diane, I want you to represent the seller here, and I'll represent Alton's company that's thinking about buying this, and kind of talk us through kind of setting it up, what a seller needs to do before, putting itself on the market.
Well, as your slide points out, I think the first consideration is normally, the seller is going to have an investment banker or advisor involved that is going to go out and try to find prospective buyers and bring them to the seller. They will then also be responsible for setting up the data room, virtual data room, electronic data room, whatever you want to call it. And usually the people that set that up are, more junior people, and they're not really aware of the risks. So from a seller standpoint, you would want to definitely make sure that you have a clean room, tie off because you don't want competitive information that is extremely sensitive to you being shared with a competitor. And you don't want to have any antitrust concerns or other concerns. So that would be one thing that you would need to cordon off and create a clean room with a clean team. Privilege issues, the same thing. You're really going to have to be very carefully monitoring your communications related to the diligence and make sure that those remain yours. There's also the transborder, transfer of data on M&A, because that's going to include employees. It's going to maybe include health information for claims. So that has to be navigated as well, along with litigation involved with any M&A deal too.
And so at the privilege issues, just to put a point on this, there's a divide in jurisdictions, Delaware and New York being prominent examples, where in one jurisdiction, it says that the data, all of the data transfers with the deal. And in the other, there can be a carve out for certain information. Well, there have been cases that have been brought by buyers who purchase a company, then look at the deal communications between the seller and their counsel and feel like they've been fraudulently induced into the deal. You don't want those communications transferred to the buyer typically. That may be something you can negotiate, but it's going to be something coming back to our legal obligations and the ethics rules to counsel our clients and say, listen, this is a risk. If you have something really sensitive or something that whatever, perhaps just pick up the phone and let's talk about it before putting it into an email that eventually may belong to the buyer. And then, of course, diligence. A seller would probably want to self-diligence first to address all the critical issues so that at the time they take themselves out, they don't have to necessarily be devalued because of some outstanding critical issue. We have just a second to talk about some deal terms. Diane, why don't you go?
Oh, yeah. I mean, from the seller standpoint, from my standpoint, I want to always limit my representations and warranties to the buyer about the condition of the company, about past practices, about compliance with law, all of that. I'm going to try and carve out as much as I can through disclosures. And this is specifically why Kate mentioned earlier, the privacy assessment, cyber assessment is key, because you can point to that you've identified and then presumably fixed things. You're going to use, knowledge and materiality qualifiers as much as possible, because you really don't know maybe what's out there, or you've, like Alton, you've hired vendors to do a lot for you, so you really don't know what they've done or not. So you want to try and limit it to knowledge. Obviously, you want to limit indemnity. You want to cap to whatever the earnout period is at the most, and you might want to consider rep and warranty insurance if the exposure is great.
And as the buyer, you want to take the opposite perspective, and then rep and warranty insurance is something that's become very hot, especially as the pace of deals seems to have increased in the past couple of years. We're now going to conclude, and the conclusion, you guys, is that the future is now. This is Sam Altman. He is the founder of OpenAI, Helion, and WorldCoin. This is real. OpenAI is an AI research and development company. Our mission is to ensure that artificial general intelligence benefits all humanity. I used OpenAI's offering DALL-E to generate almost all of the images in this presentation. It was all AI, including Alton. I said a highly detailed headshot of a handsome middle-aged man with white hair, sharp eyes, a black turtleneck on 35mm AK sharp. That's what came up. Here are some variations of our Alton. And I'm going to tell you, I did this a number of times. Never once did I get a non-white person as my handsome middle-aged guy. And this is something you'll read about quite often. Helion is building the world's first fusion power plant, enabling a future with unlimited clean energy. It's in a partnership with Microsoft, and it's aiming to power up by 2028 to provide energy for AI, which requires 5 times the amount of energy the world currently uses is what the energy demands are today, and it probably will just increase. WorldCoin is real, and you will see that it is building the world's largest identity and financial network as a public utility, giving ownership to everyone. You can get a free crypto now if you offer your eye retinal scan to the WorldCoin Foundation. You'll see on the left the orb That is the actual device that WorldCoin is using to scan retinas. And so this is happening. Everything we talked about today was real, except for Alton's vision and things. And it's just a very interesting time that we're living in. And so thank you for joining us today. I don't think that we have any questions, but we're happy to take questions, and that will be it otherwise. I guess that's it. Well, thank you all. We enjoyed speaking with you, and we hope you have a wonderful afternoon. Note that in the chat, you will find a link which will allow you to submit for CLE credit. So I'm going to just sit here and allow you to copy that link for a moment and then let Melissa close us out. Oh, Melissa, you're on mute.
That was fascinating and terrifying, but thank you all so much. And I'm echoing what Stephanie Altimer said in the comments. Everybody take some time to click on the link. Ladies, thank you so much for your time today. I know that I learned a lot, and I'm sure our participants did too. And we are going to circulate this and hopefully have it posted for you in another forum, but we will keep you posted on where to find that. So have a great rest of the week, and thank you everyone for joining us for the CLE.